Now, the minority in Parliament is yet again accusing government of engaging in an elaborate plot geared at unseating its Member of Parliament for Assin North, James Quayson. And Accra High Court today issued a criminal summons against the MP after he failed to show up in court. He is a subject of series of actions geared at stopping him from performing parliamentary duties. Now, he has been fighting in court since July 2021 when his elections as an MP was set aside by the Cape Coast High Court. The state says he's engaged in forgery and perjury, the basis of the summons that the court has issued. Court correspondent Joseph Akable has the rest of the story.
Director of Public Prosecution Yvonne Atakro-Bobisa informed the court that officials had been sent to the MP's residence here in Accra and also at the constituency, Assin North, but they have not been successful at giving the MP the court documents. She indicated that copies were posted at the residence, yet the MP had failed to show up in court once again. The court said instead of issuing the warrant of arrest as had been requested by the Director of Public Prosecution, it was rather giving an order that a criminal summons be posted at the residence of the MP here in Accra. Our sources within the AG's department say should the MP fail to show up in court on the 15th of February 2022, the request for an arrest warrant to be issued will be made once again. Richard Techimensa, who is the complainant in this particular matter, says the MP must show up in court.
I'm surprised that someone who wants to be a member of parliament to enact laws for us to obey and abide by is embarked on such a wanton disregard for the laws of the land and showing such disrespect to the courts. You've been following the civil one, and he has not been coming to court. Even a case that he himself has put before the court, his own application at the Supreme Court, he was not there. And this one, we were here last week. We were told that they made attempt to serve him. They even informed his lawyer, then sent him a text message. He did not turn up. Today, too, attempts were made to serve him. They went to the house and met someone at the house. The person refused to receive the sermon, and it was pasted on his wall. But today, he did not turn up. So the court has directed that he should be served through criminal summons, which will be pasted on his wall. Let's hope that next week, 15, when we come to court, he will be here.
So the case continues on February 15, 2022. For JoyNews from the Law Court Complex, my name is Joseph Akable.
Well, let's get some legal perspectives on this matter. Joining me now is lawyer Joseph Diop Penka. He's also a former Deputy Attorney General. He has some concerns on this raging matter. Thank you so much for joining us on the pulse here. First of all, what's the implication of the criminal summons, by the way?
Well, thanks very much. Thanks to your cherished and many listeners out there, and thanks for having me on air this afternoon. Let me say that the drama unfolding is a test of our legal jurisprudence's development as far as our nation is concerned. I call it drama unfolding because it is becoming one too many incidents in the way we try to manage our legal affairs in this country as far as the specific case of the Assin North MP is concerned. I am frightened by the development because we cannot, should not, and dare not attempt to subvert justice on any day, whoever you are, because of the supremacy of our Constitution in all cases and the principle that we are all equal before the law. So if you make any effort or attempt to subvert justice, that in itself is a criminal offense that you can answer for. So the criminal summons that the Attorney General or the criminal process the Attorney General is initiating is simply an invocation in compliance with Article 88, the mandate of the Attorney General. Therefore, I think that the best thing to do in the circumstances of this matter is for the honorable member to avail himself for trial or for the civil processes so that they can come to an effective conclusion. If it is in a criminal trial and he's innocent, he'll be acquitted and discharged. If it is in a civil case and he proves his case, he indeed will be declared to be the victor in the circumstances of the matter.
You seem to be very much confident and hold the same view with the court when they say that there's a need for some criminal summons, but there are questions about the political issues surrounding this very MP, concerns about what the minority is describing as an intent by government to use the office of the Attorney General to persecute and not necessarily prosecute defaulters. What do you have to say to that?
I will give a response in law and also make a reference for you to understand what I'm talking about. First of all, the reference I want to make is that under the government of the NDC, the Boku Central MP was tried and convicted. What was that? It was initiated by the Attorney General. He was tried and convicted and sentenced to a number of years in prison. That is correct. That one was not persecution. It was justice. But because the present person is NDC, that is persecution. I mean, how can you double speak? You cannot approbate and reprobate. You see, so I would like to say that we should look at it from an objective point of view and look at the laws of the land, whether or not we are complying with the laws of the land. The fundamental question is, there are 137 NDC MPs. Why is it James Quayson that the Attorney General is taken to court and not the other 136? That's the fundamental question you should be asking yourself. It means that he has something to answer. And I've already told you that we have what we call stare decisis. That is, our legal jurisprudence is guided by decisions of the court in the past. There are decisions of the court as far as matters like this are concerned, and they have been decisively dealt with. He is now before a civil court, and there is also criminal summons as well. So he is supposed to appear. But this issue of evading service, non-appearance, inability to avail himself in court, and etc., is only prolonging justice. But for how long? Because if he avails himself, if he thinks that he hasn't infringed any laws, he should avail himself to the court processes. And then his innocence will be established.
Where we seem to be having some difficulty now is the nature and the office that this gentleman occupies. At least the court has stripped him all of these titles. But the challenge now is about the separation of powers and the fact that the Parliament and its dealings is often referred to as the black box, an area where the courts cannot exercise complete jurisdiction. Given this challenge that we face now, how do you feel that the courts would have to approach this going forward?
My brother, we are not running a watertight separation of power system in Ghana. If you read the Constitution carefully, when you look at the functions of the executive, you look at that of the legislature and look at that of the judiciary. Each of them has a distinct function. And if you read Article 125 onwards, and then you look critically at the functions of the judiciary and all that, it is one of the functions is to make pronouncement on actions of the legislature and the executive and declare them unconstitutional to the extent that they are not in compliance with the law of the state. So if that's the adjudicating body by the Constitution to carry out this, and we say we are all equal before the law, and a person is alleged to have committed an offense and is a member of the legislature is brought before the judiciary, he's supposed to appear and answer. Otherwise, the principle of equality before the law is sentenced to death. So we need to understand the concept of separation of powers in the light of our constitutional principles and injunctions. Because no particular state entity has absolute power to exercise. And this immunity we are talking about by parliamentarians is not an absolute one. Otherwise, if we interpret it to be absolute, we will run into absurdity. Because, for example, if an MP on his way to parliament picks up a gun and shoots dead a person and is brandishing same and moving towards parliament, should we allow him to go to parliament because the law says that when he's on his way to or from or attending at, he should not establish processes of court? We should not interpret the law into absurd situations. We must interpret it in the light of the modern purposive approach to interpretation, which is that we should apply purpose to arrive at reason and look at the spirit and letter of the Constitution, the two, to be able to arrive at any decision. So to talk about the principle of separation of powers, today, if a judge commits an offense, that judge is subject to the laws of Ghana and will be tried by our courts, even though the person is a judge. So to say that the concept of separation of powers means that if an MP commits an offense, it should not be tried by the court because the executive is separate from the legislature and the legislature is separate from the judiciary, will mean a very absurd situation that we will arrive at and will make nonsense of the constitutional dictates and principles we have imbibed for ourselves since 1992.
I see how passionate you are about the law, but then there are concerns about what then happens in Parliament. What do you see as the likely implication for the MP for this area going ahead to cast a vote if indeed that comes up on the e-levy? Are there some legal ramifications for him if he goes ahead, shows up in the Chamber of Parliament to vote on the day probably Parliament is considering some other matters?
You see, when the process is served on you and you take an act that will prejudice the process that has been served on you, you can be summoned for contempt. But the point now that we are told is that the service has not been effected because even his own motions that is filed in court, he did not appear to move those motions. And it's obvious that when he appears to move the motions, he will be served with the court processes. So he himself hasn't even appeared in court. So you go to court seeking justice, and you file your process seeking justice, and when on the day of you moving the motion, you don't appear in court, you expect to have justice, you cannot have it. So I think that the circumstances of this matter are such that I would advise the honorable person, and I think that whoever is his lawyer, to do him a very good service, to allow him go through the legal processes. At the end of the day, if he is innocent, he will be acquitted and discharged. If he is found guilty, he will suffer the penalty for it. But to continue to evade service and to continue not to avail yourself to face justice will mean that you have something to hide. If you have nothing to hide, appear before their lordships, put your case forcefully, and their lordships are guided by law to arrive at a decision.
I'm sorry, but it appears you are acting naive. You're not just a former Deputy Attorney General, but you're also a former Member of Parliament. There are concerns about the numbers, so the politics of it. Why are you not mindful of that as well? Don't you feel that there's any role to be played at this point, possibly an intervention from the leadership of the House to avail, to make the MP available, given the deadlock that we have?
But even what is surprising, my brother, is that when he arrives in court, will the decision be taken that very day? It's unlikely that you will go to court and that very day all the motions will be decided by the court. They will definitely adjourn. So this point of talking about this numbers game and etc. So if for example, NPP were having 200 MPs and NDC has 75, and then an NDC member of Parliament commits an offense and is being arrested, that nobody will have a problem. Is that what we are saying? But because the numbers are tight, therefore if somebody is alleged to have committed an offense, he should be left to go because if he's taken out, then one party will suffer a disadvantage. If you suffer a disadvantage as a result of law, then that is it, because that's what our Constitution so says. But if you are going to say that, look, the numbers are tight, so the person should not be made to answer, because if he's made to answer, it will reduce their strength and they will not be able to do what they want to do. That would be most unfortunate. Because it's like also saying that flipping the coin, if an MPP member of Parliament commits an offense today, he's supposed to also go through the same process. Can you say that because he's MPP, he should not be made to go through the process? Anyway. And you see, as I've already indicated, we have the legal jurisprudence to guide us that in this country, we have convicted and jailed a certain MP before. And that was under the regime of the current minority. They saw nothing wrong with it. Today, there's a process to try one, and then they see everything wrong with it.
I see.
You cannot double speak.
Well, let's see what then happens in the future. Josephine Diok Pemka, I'm grateful so much for your time this afternoon on the poll.